labor union. Number 7, we will discuss the rights and limits of workers, employees to engage in collective bargaining and to strike, and potential impact of work stoppage. Number 8, difference between economic strike and unfair labor practice strike. 2 types of strikes: economic strike and unfair labor practice strike. And finally, we will discuss example of illegal work stoppage. Chapter overview. This chapter covers the regulations of employment relationship, especially this chapter describes the main federal and state statutory protections for the workers in the areas of wages and hours, retirement, health care, sudden job losses, work-related injuries, and workplace safety, and medical or family leave. This chapter also provides the laws that guarantee workers the right to unionize and regulations that governs labor unions. Also, provide the regulations, federal regulations that govern labor union practices and employer conduct in regard to dealing with the labor unions. Okay. Overview of employment regulations. The origins of employment regulation will be appear on your textbook, page 55. Please read your textbook, page 55. Okay, there are 2 types of employees: contractual employees or at-will employees. Origins of at-will employments. Historically, if no employee contract exists, there is no employment contract. In that cases, the employees, the workers, work under the at-will principle, at-will doctrine. Okay, at-will employment means that the employer can fire his or her employees at any time without any reasons. That is the at-will employment. This traditional employment at-will rule is first appeared around 1870s. This at-will employment is too harsh, too hard to the workers. Therefore, certain limitations to this at-will employment doctrine has been developed on the federal level and state level. What is the employment at-will doctrine? This doctrine permits the employers to fire an employee without advance notice and without just causes, okay, that is done on at will employment. But there are some exceptions to this general rule. There are 3 exceptions. Okay? This employment at will doctrine does not apply in all cases. 3 exceptions. These 3 exceptions at the employee does not apply. First, the employee has a right on express contract with employer. In that case, at the employee, not apply. Number 2, second exceptions, common law exceptions. Third exceptions, specific statutory exceptions. Wrongful discharge. Under this common law at will employment, the employer has too much strong power because they can fire, terminate his or her employees at any time without any notices. Okay? Therefore, most states, 50 states, recognize some exceptions to this traditional at will employment rule. Under these exceptions, a terminated employee, a fired employee may sue the former, his or her employer for wrongful discharge or unjust dismissal, or the terminated employee may also may sue against the employer based on the torts law or based on the contract claims. First, exceptions to the general rule is the express contract. A major exceptions to the employment at will is occur when an employee has an express, written, contractual relationship with the employer. This express contract will displace the employment at will law. Okay? Implied contract is another exception. An employment at will relationship may be converted into a contract relationship if the employer has been acted in a manner that would lead the reasonable person to believe that the employer intended to offer an employee protections from firing, from termination, without clauses. Okay? That is the implied contract doctrine. Second, exceptions to the general rule is the public policy exceptions. Public policy exception is the common law rule. That common law rule places the public welfare ahead of the rights of the employer. And allows employers to fire an employee for certain reasons that contradict public policies. This public policy exception is a narrowly applied common law rule. Currently, the courts has been reluctant, does not like to expand the narrow public policy exceptions. Under the state public policy exceptions, the terminated employee claims discharge. My termination was wrongful, unlawful, because my termination is violated against state public policies in one of three ways. Okay? The employee has a legal right to refuse to commit unlawful act. The employee has a legal right to perform public obligations such as military duty, whistleblowing, and jurors. Sir, employee has a legal right to exercise legal right or legal privileges. Sir, exceptions to the general rule is a statutory prohibitions. Two types of statutory law: federal law, federal regulation, and state regulations. The certain federal statute and certain state statute also displays the common law employment at will rules. This statutory prohibition includes the whistleblower statute and anti-discrimination laws and jury duty laws and attempting to form union laws are the statutory exceptions. Okay? Okay. One of the most important statutory exception is a whistleblower statute. A whistleblower. Who is a whistleblower man? a whistle blower is defined as an employee who publicly disclose the dangerous behavior of employer, disclose illegal behavior of his or her employer, or disclose improper behavior of his or her employer. Okay? The employee disclose this illegal act of employer to the government authority. That employee is referred as a whistleblower. Federal employees are protected from retaliations for whistleblowing by Whistleblower Protection Act. This Federal Whistleblower Protection Act was passed 1989 in the Congress. Under the state level, each state follows its own whistleblowing statute. But most commonly, whistleblowers are protected when they report the violation of law by their employers against the government authority. Okay, employment regulations, statutory prohibitions. The Congress, Federal Congress, and state legislatures have passed the law. That law are intended to protect employees from employers' oppressive practices or employers' unfair practices in the workplaces. Therefore, the federal government and state government regulated these oppressive practices, okay, in the workplaces. One of the most important regulation of employment regulation is a Fair Labor Standard Act. This Federal Fair Labor Standard Act was passed in the Congress in 1938. The centerpiece of wages and our laws protection is this Fair Labor Standard Act of 1938. This Fair Labor Standard Act is intended to cover all employers engaged in interstate commerce in providing for areas, payment of minimum wages, maximum working hour, maximum 40 hours per work week. Third, overtime payment. 4, Fair Labor Standard Act also prohibit the oppressive child working. Okay, minimum wages and maximum hours under Fair Labor Standard Act of 1938. Federal government regulate employees' wages and hours under Fair Labor Standard Act. This act repeatedly amended every year to keep the minimum wages and maximum hours up to date. Minimum hourly wages under Fair Labor Standard Act is that currently federal minimum wage is $7.25 per hour. This is a federal minimum wages. However, each state are permitted to set a higher minimum wages level. Okay? LA County minimum level is wage level is I don't know exact amount. The increase for every year. $12 to $15 per hour. This minimum wages for 1 hour will be increased rapidly every year. Okay, every state has higher minimum wage level than the federal minimum wage level. What is the maximum hour? Minimum and maximum number of hours before overtime. Is that maximum hour per work? Maximum hour. The employee can work maximum 40 hours for 1 week. If the employee work more than 40 hours per week, then 1.5 regular rate will be applied. But this maximum hour per week may be superseded by contract. Exempt employees. Fair Labor Standard Act does not cover all workers. The exempt employees are exempt employees are the executive employees, workers, the administrative workers, the professional workers are exempt. Another apply the minimum wages, another apply the maximum hours. Okay? Examples of employees that are not covered by Fair Labor Standard Act include the following 4 categories. Professionals that require the specialized study and specialized certifications. Category 2, management employees, supervisory employees are not covered by this act, are not covered. Minimum wages and maximum hours. Category 3, the computer programmers, the computer engineers are not covered by this act. Category 4, employers subject to certain certifications and subject to regulatory requirements are not covered by this Fair Labor Standard Act. This case, Barcon versus Starbucks Corporation, is a famous case for minimum wage and maximum hour cases. Please read this textbook. Read these cases in your home. Okay? Okay. Next subject. Employment relationship and labor law is pension regulations and regulations of pensions and regulations of retirement account. Retirement. Every individual live in the United States of America have a legal right to retire at the age of 62. After the age of the 62, everybody has a legal right to receive a pension from Social Security agencies. The employers are not required to establish retirement plan for their workers. However, some or most employers, business, offer a pension plan or offer tax deferred retirement saving account such as 401k plan in order to hire, in order to attract, in order to retain the high quality workers. Therefore, the business, the employers that established retirement benefit are subject to the requirement of Employee Retirement Income Security Act laws. This ERISA law, Employment Retirement Income Security Act of 1974 requires every employers to make a certain disclosure that is related to investment risk in the retirement trustee, and employers must provide transparency to plan beneficiary. Okay, this ERISA was passed 1974 in the Federal Congress. This ERISA Act imposes the fiduciary duty on pension fund managers and enforces the record keeping, reporting, and disclosure requirement to the intended beneficiary. The remedies for ERISA law violations include the civil suit against employers by plan participant, and the plan beneficiary have a legal right to sue against the employers for the reason of ERISA violations. Also, retirement plan participant and beneficiary compensate based on equitable relief and the criminal penalties. Social Security. In addition to any pension and retirement plans offered by employers, individual persons are entitled to retirement income from the federal government by virtue based on Social Security Act of 1935. This Social Security Act provides the retirement income every person at the age of 62 has a legal right to the qualified individuals has a legal right to receive the retirement income from the federal government under the Social Security Act of 1935. Minimum retirement income for individual person is $760. This retirement income per every month will be increased according to the inflation rate. Therefore, qualified individual person can receive the retirement plan from the employer's retirement plan and Social Security income from the federal government. Okay? After the age of 62. Healthcare. The employers are not required to provide workers with healthcare insurance or healthcare plans. However, the employers do provide employees with the healthcare plan and insurance. In that cases, the following act will protect the employees. First, the Consolidated Omnibus Budget Reconciliation Act of 1986 allows for employees to continue to purchase health insurance even after his or her employment is terminated, is finished. Okay? Another act is the Health Insurance Portability and Accountability Act of 1996. This Health Insurance Portability and Accountability Act protects employees with pre-existing health conditions when they change their jobs. They continue keep health conditions. For an update on the new federal regulations in the area of healthcare, currently the Healthcare and Education Reconciliation Act was passed 2010 in the Federal Congress. See the textbook website at the following website. Okay? Okay. Certain job losses. Everybody can be terminated anytime without reason by his or her employers. What can I do in that cases? Certain job losses. In that cases, the Federal Unemployment Tax Act FUTA provide the limited payment to the unemployment individuals, maximum 2 years. Okay? This Federal Unemployment Tax Act was passed in 1935. Under this FUTA, federal government give the money to the terminated workers. Also, State Unemployment Tax Act. Every state has a State Unemployment Tax Act. That is referred as a SUTA. FUTA and SUTA provides the limited payment that are funded by employment taxes to workers who have been terminated, temporarily terminated, or permanently terminated from employment through without no fault of their own, without any reasons, terminated without any reasons. In that cases, FUTA and SUTA provide some money to the lost workers, okay? Job lost workers. Plan, closings, facility, closings. In that cases, what can we do? What can workers do? The One Act will protect these cases. One stands for Worker Adjustment and Restraining Notification Act. This One Act was passed 1989 in the Congress. Under this One Act of 1989, the employers that intended to cross down on entire facility, or employers who intend to fire, lay off 50 workers or more than 50 workers must provide advance notice to the prospective terminated employees. The employers must provide at least a 60-day written notification of a facility closing and 60-day written notification of mass layoff, mass termination of employees under the One Act of 1989. Workplace injuries. All states, 50 states, currently 50 states have workers' compensation statute. Under this, California workers' compensation statute, under the California Workers' Compensation Statute, if employer does not insure the workers' compensation insurances, in that cases, the state levy the penalty of $1,000 for one workers for each workers. Assume that employers have 10 workers, 10 employees, and does not insure the workers' compensation. In that cases, state government levy the $10,000 penalties. Okay? All 50 states have workers' compensation statute that provide an employee who is injured in the course of employment must pay a partial payment funded through employer paid insurance policies in exchange for mandatory relinquishment of the employee's right to sue his or her employer for the tort of negligence. Negligence tort, based on the negligence tort, the injured employee can sue against employer based on the negligence tort claim. Okay, another area is a regulation of workplace safety. Federal Occupational Safety and Health Act of 1970 makes the workplace, the employer must make the workplace as safe as possible for workers who is engaged in business operations through following four standards under this act. This act is very, very strict. This act is referred as OSHA. OSHA stands for Occupational Safe and Health Act of 1970s. Okay, Cisco versus quicker recovery in company is a famous landscape case for the workers' injury cases. Please read these cases in your home. Okay, another important regulation, federal regulation, is the Family and Medical Leave Act. Family and Medical Leave Act was passed in 1993. This Family Medical Leave Act guarantees employees unpaid time off for the family reasons, for the medical reasons. Prior to this Family and Medical Leave Act, it was very, very common for the workers to lose their job when they have serious illness. When the workers have a sick, it means that he lost his or her job prior to the Family and Medical Leave Act. This Family Medical Leave Act applies to employers with at least 50 employees within 75 miles. This act mandates that the employers must provide maximum 12 weeks of unpaid leave to the workers for the purpose of caring for workers' family, medical matters during any 12 months period. Family medical leave eligibility circumstances include the following situations. Workers can leave when birth and care of his or her newborn child of employees, adoption, or forced care placement. In that cases, workers can leave for the medical or family purpose, care purposes, and care of immediate, very, very close family members with serious health conditions. In that cases, workers can leave for the family matters, family members with qualified accidents that is arising out of being called to active duty in military. In that cases, the workers can leave for the family matters. Okay, another area is employee privacy matters. The overview of employee privacy. The privacy of employees is an issue of growing concern. Big issue of growing concern because many employers regularly monitor employees' behavior in some kind of form. The employers are interested in surveillance of workplaces. The employer interest in surveillance of workplace may conflict with the workers' private interest. Generally, an employee's right to privacy in the workplace is very, very limited. However, the employees may have some limited rights that are typically provided by federal statute and provided by state statute, unless otherwise specified by federal statute. U.S. Constitution does not apply to private employment. Generally, federal privacy laws typically apply only to federal workers, and state law covers private sector workers. Monitoring of emails and internet usage. The companies typically adopt the specific guidelines and adopt specific policies for email usage, for internet usage. And the company typically inform workers through employee handbook, etc., that all internet usage and email is subject to monitoring. Employee handbook includes this: email usage, internet usage, and this usage is subject to employers' monitoring. Telephone and voicemail. The Electronic Communications Private Act, Federal Electronic Communication Private Act, restrict an employer from monitoring on workers' personal calls and assessing on workers' office voicemail without their consent, or unless it is in the ordinary courses of businesses. Okay? Drug and alcohol testing. Most states permit the workers testing so long as the employer follows the certain procedural safeguard that is intended to ensure confidentiality and safe and the accuracy. This drug and alcohol testing is usually allowed of any at-will employee or at-will applicant. Polygraph testing. Polygraph testing or lie detector testing. Polygraph, lie detector. The Employee Polygraph Protection Act of 1988 prohibits the most private sector employers from requiring a polygraph lie detector test as a condition of employment. The employers are prohibited from taking action against the workers who refuse to take the lie detector test. Labor unions. Another sources of legal protections for workers is through labor union. Until the National Labor Relations Act of 1935. This act is referred as a Wagner Act. Until this Wagner Act of 1935, U.S. workers who is attempting to organize the union to obtain better working conditions and better working pay was treated just like criminals. Okay, until the Wagner Act of 1935, the workers who want to organize union will be treated just like a criminal. However, National Labor Relations Act protected the union. Okay, as of 2018, only 10.5% of employed workers belong to the union, according to the U.S. Bureau of Labor Statistics. National Labor Relations Act of 1947 provide general protections to the right of workers to organize and to engage in collective bargaining. The workers can use the economic weapons, such as the strike, in the collective bargaining processes. The National Labor Relations Act requires that both parties, employer and employee, engage in good faith negotiation. This is not a requirement that one side or other side